now request Mr. Dharamchand Jain, former Special Director of CBI, who is also the present Chief Operating Officer of Indian Police Foundation, to speak on the new criminal laws. He will be the moderator for the coming panel discussions, but it will be useful to listen to him about what are the salient features of the new criminal laws, what are the strengths, what are the concerns, and what is it that we can do by codifying or compiling our suggestions, which can be brought to the notice of the authorities that be. Thank you. Over to Dr. Dharamchand Jain.
Thank you so much, sir. Thank you. KP Singh sir has already given a good outline of the new criminal laws, the background, the history, and how long it took, and what all kind of deliberations took place before the new criminal laws were enacted by the parliament. So, as is the theme of the day, that navigating the new criminal laws and implementation challenges. Basically, as we all know, our criminal justice system is run by three kinds of criminal laws: penal law, procedural law, and the evidentiary law. We all know what is penal law. Penal law is the one which defines which acts make an offense, and it also prescribes penalties for the same, punishments. Earlier it was IPC, and now it has been replaced by Bharatiya Nyaya Sanhita. Then we have this procedural law, and procedural law is the one, from the practitioner's point of view, from the citizen's point of view, I think it is the procedural law which holds the place of primary importance. Because as a citizen, suppose if you are a victim of a crime, then how do you report, where to report, what are the rights of a victim, what are the duties and responsibilities of the police when they receive information about crime, what are the powers of the investigating officers, what all it can do, what it can't do, what are the powers or rights of the arrested person in case arrest happens, then what will happen in the courts, appeals, trials. All these things are governed by the provisions given in the procedural law. The earlier procedural law was the Criminal Procedure Code. That has now been replaced by the new procedural code that is known as Bharatiya Nagrik Suraksha Sanhita. So from the practitioner's point of view, as I see, it is this procedural law, I think, which is the most important thing, because even as a common citizen, I must know what are my rights, what I need to do, where I can go, how I can report a crime. All those things are given in the procedural law. Then, of course, we have the third is this evidentiary law. And what is evidentiary law? Basically, it tells you about the admissibility of the evidences, basically what all types of evidences are collected during investigation or inquiries, what will be admissible, what will not be admissible, when these evidences will be presented in the court of law. So it is not easy for any country, as we can appreciate, to change all the three laws. So in a way, we can say that this country has made a history in the month of December 23, when all these three new criminal measure laws were changed. Now, from the citizen's perspective, basically from the common man's perspective, what are the positive things in the new criminal laws? Particularly the BNSS, as I said, these laws are stated to be victim-friendly. Now, when we say victim-friendly or victim-centric, the primary emphasis is that the victim should have an easy access to the justice system. Right, because the first and foremost, as Harish Kumar sir was also mentioning, I think even today it is not so easy. I mean, the common man of the country is not very confident that if he or she will become victim of a crime, whether his report will be entertained in the police station or not, whether the FIR will be registered in the police station or not. So in order to, I think, address these concerns, then there are certain provisions which have been made in the new criminal laws, I think, which all of us need to know. One is one of the biggest complaint of a common man is that when he or she approaches a police station, generally they refuse to entertain the information on the ground that this particular crime has not happened in my jurisdiction. So you have to go to the police station where this incident has happened, and many a times the poor person doesn't even know in which police station this particular crime has happened. The problem, I think, is more compounded in cities, because in a particular city, like in a place like Delhi, where there are more than, say, 100 police stations, a common man is not supposed to know which crime in which police station. So this concern has been addressed. Now the new law says that the police station where the victim reports the crime, it is this police station which will have to compulsorily, mandatorily register the crime. They will not be able to they will not be able to refuse on the ground that the crime has not happened in my jurisdiction. So now it is for this police station where the information has been received that they will decide that which police station we have to transfer this FIR for registration and further action. So I think a big worry of the complainant or the victim has been taken away by making this provision, what we popularly call as zero FIR, registration of zero FIR. Then one more important change that has been made in the new criminal law is that earlier, as per the scheme of things in section 154 of CRPC, the informant or the victim has to personally visit the police station for lodging the FIR. Now they say, those who are familiar with the technology and in this era where when everyone has these smartphones with a lot of data connectivity, you don't have to visit the police station for lodging your FIR. It can be lodged by, the information can be sent by electronic communication also. And we can imagine how good it is going to be, particularly for those who are elderly citizens, those who are women, those who are children. So there is no requirement of now physically visiting the police station for the purpose of getting your information registered. So I think this is also a very important development that has happened. Another thing is, and again, because these are the issues relating to the habits and cultures also, the way our police forces function in this country. If I am the victim or I am the informant, I think I'm interested in knowing what happened to my complaint. What is the progress of investigation? And as we know, police generally, the culture is कि हम पूछते हैं, हम बताते नहीं हैं. Isn't it? You understand? We only seek information, we don't provide information. So I think this particular concern of the complainants has also been addressed. Now it is a legal right of the victim or the informant to know the progress of investigation. Necessary provisions have been made in BNSS. So that is also a very important change that has been made. Then many of you would know there is a provision in the law that the state has the right to withdraw any criminal case from prosecution. What is the meaning of this? That after the charge sheet has been filed, if one fine day the state government or the central government, as the case may be, if they decide that no, we will not carry prosecution of this case, we will withdraw. They may withdraw, they have the powers. Imagine from the point of view of the victim. The victim feels cheated because victim doesn't even know that the state decided to withdraw from the prosecution. In the new criminal law, now they say the state application of the prosecution filed on behalf of the state, the court shall not allow such application unless the victim is given an opportunity of being heard. So the victim will first be heard before such an application of the state is allowed. Then there are many changes relating to, one of the ban of the Indian criminal justice system is delayed justice. There is so much delay, like during investigation, and of course during trial also. Our courts notoriously take a lot of time in deciding cases. If one thing, one may say, one of the salient features of the new criminal laws is there is so much emphasis on the use of technology. They want the courts, the investigators to use technology. For example, suppose if the police wants to record your statement, now the new law says you don't have to call a person physically to the police station for recording his or her statement. They are promoting that by audio video means electronic communication, please record. Same thing applies now to the trials also. So they say, like, if I have to go to the court as a witness, I don't have to go physically now to the court. Of course, states will have to set up these designated centers with state of art facilities. Only then these changes will become more effective. But the provision has been made in the new laws that practically now most of the things which happen in the trial courts that can be completed by audio video conferences, video conferencing as we popularly call. Then timelines have been prescribed. There are 35, like in the BNSS, there are at 35 places they've given timelines for completing a specific task. For example, if I may say, those of you, because I can see many law students over here, when trial happens, you see, like you may have heard, first the thing is that the police report or the charge sheet or the documents, a copy is supplied to the accused. Then the accused has a right to kind of, accept or deny the documents, and thereafter the accused has a right to file what we call as discharge applications. Now, what is the meaning of this? The meaning is that after having looked at the evidence presented by the police, the victim may say, there is no evidence against me. Why should I face the trial? So I am entitled to be discharged at this stage. So they are entitled to file what we call as discharge applications. Now in practice, what happens in a case where there are multiple accused, maybe say more than 10. So each person will file a discharge application one after the other. And if the application is not decided in favor of the accused, then that person will file a revision petition. The record of the trial court will go to the revisional court. As a result, we have seen cases in CBI where years have taken by the courts in deciding these discharge applications. Means your trial has not even begun and years have passed. Even the charges have not been framed against the accused. So in the new law, for example, they say, once you have been supplied with the documents, you have accepted the same, you have a period of 60 days. So within 60 days, if you want to file discharge application, you can file. But after 60 days, the discharge application will not be entertained. I think if you ask me, this is one timeline which will change the way trials have been happening in this country. Similarly, for each thing, there are different timelines. And one more thing, many of you you might have seen this film Betab of Sunny Deol, where he makes this famous dialogue that in Indian courts, केवल तारीख पे तारीख मिलती है, justice नहीं होता, केवल तारीख पे तारीख मिलती है, तारीख पे तारीख, तारीख पे तारीख. So I think the new criminal laws have taken care of that. They say now the court shall not be able to give more than 2 adjournments. 2 से ज़्यादा तारीख नहीं मिलेगी on the request of either party. So idea is to expedite the trials. And there is so much emphasis, like the way the evidences of the experts, medical jurists, forensic scientists. If you ask like those who are forensic scientists or medical experts, if you ask them, why do they delay in examining the exhibits and providing us expert reports? One of the primary reasons is most of the time they are in courts attending evidences in the previous, I think, reports which they have provided. So now in the new law, they say, first of all, why should they have to go? Unless the report is disputed, they should not be called for evidence in the court. Secondly, in case there is a necessity, and if the person who was an expert, if he is transferred, is retired, he is not available for any reason, then you should take the evidence from the successor, means the person who has been occupying that seat at that place. And also, again, don't call that person physically, call that person, examine that person by the video conferencing. So if examination of these witnesses start happening by video conferencing, obviously a lot of time of the court will be saved. I think a lot of inconveniences the witnesses are put to. We know in many times the witness
travel far distances, they reach the court, and the poor people are told, today your evidence will not happen. We'll let you know when you have to come next. So I think those kind of uh, issues will be tackled. Then these are certain things about the BNSS I wanted to say. Not only here, but even in, the Bharatiya Nyaya Sanhita, which has replaced the penal law, you must have by now come to know they have added certain new offenses. So, if I may say, organized crime. So in IPC, there was no such crime, and in certain states, of course, they have special laws. Like in Maharashtra, a very popular law we know as what is known as Makoka in Maharashtra. Similarly, on the same lines, we have one special law in Gujarat. But in most of the states, we do not have a law to deal with this organized crime. You may have heard of these gangs like Lawrence Vishnoi gangs. They have been playing havoc, and I think they do indulge in a lot of these extortion activities. So, in order to tackle these kind of serious crimes, they have for the first time defined what is an organized crime. And if you ask me, it is quite a comprehensive definition. It covers almost all situations. And earlier, whenever we would talk about a serious offense, generally the law would prescribe a condition where unless the person has previous history of convictions, you would not be able to tackle that person in a more serious crime. So instead of this condition of having previous convictions, they have now replaced with the previous charge sheets. So if a person was earlier, say, charge sheeted in a similar crime in more than 2 cases, now that person will be able to be booked under the organized crime, which is, I think, a more serious crime. Then taking, I think, they have taken concern of many other things. Certain crimes, by the way, have been made gender neutral. It could be very interesting to know. For example, if I may say, like, we know outraging modesty of a woman. When you use criminal assault or force on a woman to disrobe her, in the earlier law, in the IPC, only a male person could be booked as an accused for this particular crime. Now this has been made gender neutral. They say even a woman can subject another woman to this kind of assault. So even the woman can now be booked under the BNS. So this is similarly, there is another crime, what is known as voyeurism. Voyeurism means when you peep into the private life of a person. So again, earlier only a male person could be booked as an accused. Now this has also been made gender neutral. Even a woman, if they do this kind of act, they can be booked for this crime. So similarly, there are many other, I think, changes that have been made. In the evidentiary law, also number of changes have been made, though this is one law which has not been changed much, because in the previous law, that is the Indian Evidence Act, there were 167 sections, against which now in the new law, that is this Bharatiya Sakshya Adhiniyam, they have 170 sections. So not many changes, but what are the important changes they have made? They have expanded the definition of primary evidence. Those who know, the courts always insist that you must produce the primary evidence. I will accept the secondary evidence only when you are able to convince me that the primary is not either not available or you are not in a position to bring the primary before me. For example, sorry, we all know about the electronic evidences, because in electronic evidences, basically the huge storage mediums like servers, loggers, on which like lakhs of other data is stored. You may be interested in one file, and that particular machine has 1,000 other files. So obviously it is difficult to seize original and produce original before the court. Otherwise, many a times, suppose if I read a company and if I take the server out of that company, obviously its operations will be put to a halt. So the law has taken care of that. They say in certain these kind of situations, you don't have to bring the primary. You only obtain the copy of that file in which you are interested, but there are certain riders. That file will be admissible only when you obtain a particular certificate, what we popularly call as Section 65B certificate for the admissibility of electronic and digital evidence. So, keeping in view these issues, they say, why don't we expand the definition of primary evidence itself? And now let us try to think of situations where more and more kind of examples would be considered as a primary evidence. If I may give an example, suppose if we are broadcasting this program at number of locations, and the program is being recorded simultaneously. Simultaneously is the key word here, not in a series, but parallelly, simultaneously, together at the same time. The new law says each such recording which is being done simultaneously at multiple locations will now be treated as a primary evidence. So these kind of things. Similarly, in the secondary evidence also, in the definition of secondary evidence, they have expanded the scope of this definition. If I may give an example, there are many endangered manuscripts which are kept in our national archives. Suppose if there is something, some content in one such manuscript or book which is very delicate, we can't even make a photocopy out of it, it can't even be lifted, it can't even be photographed. Then if there is some content in that book which I want to like prove in the court of law, how do I bring the primary? I can't bring. So, and there is no photocopy available. So how do I prove? I am not even able to produce the secondary evidence. In the new criminal law, I think this concern has been taken care when they say now oral admissions and written admissions will also be accepted as a secondary evidence. Now what is the meaning of oral admission over here? It means if there is an expert, someone who claims that I am an expert, I know what is written in that book. Maybe someone who did a research on that particular theme or subject. Maybe someone who wrote a book in which this particular book or manuscript was referred to. So someone who can be fairly considered as an expert, if that person is presented as a witness in the court, whatever this person states as oral statement, oral admission, that will be accepted by the court as a secondary evidence in order to prove the content of such books. They have also, I would say, changed the definition of the expert. Because ultimately, as we know, in the evidentiary law, whose opinion is acceptable in the court? It is only the opinion of the expert, not the opinion of any other person. Someone who qualifies to be called as an expert in the law, it is only this person's opinion which can be accepted as the expert evidence. So many a times, like we all know about these forensic experts, we all know about the experts of the document examination, questioned documents, etc. But there may be many other fields where a person, because that person has worked in that particular field for many years, by virtue of that experience, this person qualifies to be called as an expert. Say, for example, if I may give an example, revenue field, because police does lot of investigations relating to land disputes, revenue records, etc. There are many matters. Suppose if you want to examine a person who is an expert in the field of these revenue, land records, etc., someone who has worked, say, for 20 years, 15 years, 30 years, now you will be able to present the opinion of such a person as expert's opinion. Because now they say any other field, expert in any other field has now been added into the definition of the expert given in this. But note that everything has been made easy. Certain changes have made things difficult also for the police in the new criminal law, particularly regarding the admissibility of the secondary electronic evidence. Because as I mentioned in the earlier law, in section 65B of the Indian Evidence Act, there was a requirement of seeking only one certificate from the machine handler. Suppose if this is a machine in which, suppose there is a voice logger in which we record the calls. So the one who handles that machine, who is the in charge of this machine, I would obtain a certificate from that person that yes, it is me who handles this machine. I know what are the contents inside it. I can certify the authenticity or the integrity of the recordings. So it is me who has made a copy and I am giving it to you. I certify with this certificate, this will become admissible. In the new criminal law, they say in section 663 of the Bharatiya Sakshya Adhiniyam, Now you will require to obtain two certificates. One from this person who has been handling the machine, and also a certificate from an expert. Incidentally, the who will be an expert for providing this second certificate for making the secondary evidence admissible, secondary electronic evidence admissible? Uh, Unfortunately, the law is silent. So, how do I know from which person to obtain this second certificate? Now there are multiple interpretations of that. So some people say, okay, look at the definition of the expert given in section 39 of the new law. When we go there and we look at the definition, we find it says that for the purpose of electronic or digital evidence, an expert is a person who has been defined as an expert in the Information Technology Act, section 79A. So when we go there, we find that the expert for the purpose of this act or this section would be an agency which is certified to be so by the Ministry of Electronics and Information Technology. When we go and look at their list, we find so far they have only given certificate of examining these electronic exhibits to about some 20 odd agencies, not persons. Laboratories, mostly the central government laboratories, not even the state laboratories. So obviously they would not be able to fulfill the objective of the requirement of section 63. It is very simple, because now, for example, you know, the most common thing that we do during investigations these days is we collect call records, because everyone is using a mobile phone. I want to know to whom this person talked to. I want to know whether this person was actually present at this place when the incident happened. Then obviously I want to know, I want to find out his location as per the tower details in the call records. So I am seeking what we call as CDRs, call detail records. Earlier, the nodal officer of that service provider will give me the section 65B certificate. Now, police, like if you ask the officers from Delhi police, they would tell you they have been seeking CDRs every day in thousands. So who would give the other certificate, which is now required as per section 63? From where will you bring so many experts? I don't think this expert as defined in section 39B would be of use to us. So these are the areas of concern also. Then there is perhaps some other section, what is known as section 329 of BNSS. There also they define the expert. But if you ask me, it would not be easy for the police to obtain this second certificate. Then, you know, there are many other areas also. Achha, one more thing, you know, which is, I think, relating to the use of technology. One of the most important work of the police in a police station, if you go and see, is servicing of summons issued by the courts, isn't it? If you go to a typical police station, you will find that more than half of the police personnel are busy, or they have gone out of the police station to service the summons which were received from the courts. So the new law says, why to engage so much manpower for the purpose of servicing summons? So they say that, okay, court shall issue the summons in electronic form, digital form, with digital signature, or with the image of the court seal, and police would also be able to, I think, serve these summons electronically. I have got a signal that I think the chief guest is about to reach, so I think more discussions we'll have during the panel discussions. I think the panelists will throw more light on this. Not that everything is good. I think there are areas of concerns also in the new criminal laws. I think we need to educate ourselves about that also, particularly those who have the responsibility of implementing the new criminal laws, particularly the state governments, particularly the police leadership, the DGPs of the states, as we would try to bring out during today's these two panel discussions. There is so much for the state and the DGPs in particular. the way they will implement, the way they will issue the guidelines, the way they will issue circulars, I think a lot will depend whether wherever there are discretions given to the police station authorities in the new criminal laws, how they will be used, whether they will ensure that they are not abused or misused and they are not used for harassing innocent people. I think a lot will depend on the police leadership. So with this, thank you so much, sir, for giving me this opportunity. I think we'll have more on this. Thank you.